All right. We'll call the meeting to order. First item would be a roll call from my left. Go ahead and start.
Bill Mason, Greenbrier.
Keith Whittington, Johnson City.
Mark Broad, Knoxville.
Reese Smith, Franklin.
Cindy DeBus, Knoxville.
Marvin Sandrell, Columbia.
Okay, and let's discuss the agenda. It's been brought to my attention that we ought to try and move the bond guarantee report up as far in the agenda as we can to allow some of these people that are here for that to leave after that discussion. So I'll move that up right after hardships, unless anybody has any objection to that. Okay. Any other additions or changes to the agenda?
Make a motion to approve the agenda as amended.
Second.
All in favor, say aye.
Aye.
Okay. Motion carries. Bring up the hardships approved by the executive director.
These have all been reviewed and approved by a board member.
Make a motion we approve the hardships.
Second.
Any discussion on the hardships? All right, all in favor of approval, say aye.
Aye.
Any opposed? The motion carries. All right, we'll talk about the guarantee agreement and the bond. Yeah, just for the record, if you would note that Ernest has joined the meeting.
To get the issue started, I'll remind the board the last major discussion on this was in March, and the board voted to have I and the executive director draft a report summarizing the evolution of the issue with the guarantees, and I believe that's on your iPads. Is it, Carolyn?
Yes.
Okay. Carolyn did a chart, and then I did just a short memo about what's happened with it, and tried to give sort of the position of different parties. And of course, we've got several parties here today who I think want to address the board. But what started this whole issue was a rulemaking last year in March of 2012, and I had a rule on there regarding personal guarantees and how they're utilized by the board in setting monetary limitations. And at the same time, there was a civil case going on in Williamson County against a licensed contractor, and it involved one of these personal guarantees, and he was being sued personally by the homeowners. And there was some argument that the guarantees weren't constitutional. And so we dropped that part of the rule at that time. We withdrew it because there were so many questions about the personal guarantees. And so since that time, the board has heard different positions about the intent behind the guarantees. Was the intent to secure obligations to the board, or to secure obligations to consumers or customers of contractors? And the final disposition as of March was that the intent is to secure obligations to consumers, and the board also made some changes to the forms to assist contractors in understanding the actual liability that they can incur by signing these. we added a limitation, a monetary limitation to them, and we also added a time limitation. So each each guarantee that's now on file will expire at the time that the license is up for its next renewal. And also, the board has voted that they consider these guarantees to be part of the financial statement and to be confidential pursuant to statute 626124. Some issues regarding that have been consumers are having, or consumers and their attorneys are arguing that these should not be confidential because the intent behind them is to protect the consumers, and that to obligate people to submit a subpoena, which is what they have to obtain the knowledge of even their existence in the file, is against the policy for which they were even created. So the argument is consumers should be able to at least know the existence of them and to obtain that one sheet of paper being the guarantee form, not the actual financial statement that comes with the guarantee form. The issue that came up, so I've laid out the evolution. An issue that has come up with Carolyn is a stamp that the board voted on to use to stamp these forms when the renewals come up to reflect that they are now expired. But the problem is we have some forms on file for licenses that expired in the past. So, for instance, a license may have expired in 2008, and there is a civil case going on now, and we get a request for subpoena, and the question is, what does the board consider that guarantee to be? Is it expired? I think it's pretty obvious to me that it is expired, and I just suggested that the stamp that Carolyn orders, from Staples or wherever she's going to get it, would just say the guarantee was signed on this date and the license expired on this date. And she had a suggestion that it give a little more information about what time limit it would be good for projects on, as if telling maybe somebody when it could cover damages or not. And I felt like that was going too far with information that really it's for a court to decide. So I would like that question answered today by the board, just to vote on what exactly the stamp should say. But also I'd like to bring up probably the biggest part that I have to contribute today, which would be that after researching this and doing my report, I feel as if the answer, and I may just want the board input first, I guess, before I give a conclusion, or maybe you may not want my recommendation. I felt like in March you did, but I'll let you guys discuss anything you may want to before I make maybe my final legal recommendation about what I think the status should be, if there's any discussion, or if you want to hear from the public. And I'll just go ahead and say it. I feel like it's against probably the original intent of the guarantees for them to be confidential at this point and part of the financial statement. In doing my report, I spoke with a certified public accountant who stated that the financial statement is a technical term used by accountants in the business, and that in his opinion it would never, the guarantee form as written as he saw it would not be considered part of that technical term, that it would be considered financial information but not part of the financial statement. And in my opinion, when you start looking at all of our documents, which are public records, and you start looking at making exceptions to the public records status, which is all of our records are public records unless there's an exception. An exception can be, as stated in other laws, but you have to strictly construe those other laws. And this other law says financial statements are confidential. And just based on my research, my opinion is that if you want to narrowly construe financial statements, that the guarantee form itself would not be part of it.
Didn't the Attorney General, though, rule that this board had the authority to consider the guarantee agreement a part of the financial statement?
That was part of my report as well. That's true.
Okay. Then the answer to that is yes. My opinion is.
But there's no formal opinion. I guess I do want to say that.
Okay, but so far that's what we're working on. That was an informal opinion from the Attorney General.
Right. I would.
Right.
Okay.
We require a certain financial status to qualify for a limit. If you're going to get a $200,000 limit, then you have to have a certain amount of assets, or a bond, or a guarantee agreement, or a letter of credit, or some combination thereof to qualify for that $200,000. To reveal that we've required a guarantee agreement, or a bond, or a letter of credit reveals to some extent where an applicant stands financially by necessary inference. So for us to make the letter of credit or the guarantee agreement or the bond public record, but not their audited financial statement, seems to me to make revelatory information available about the contractor. And that's the purpose of confidentiality, is to not put them at a competitive disadvantage because of some understanding about their financial situation.
But the statute does not say, the exception to the Public Records Act that we have here does not say financial information.
Okay.
It says financial
But
statement.
we're working under an informal opinion from the Attorney General that says this board has the authority to decide that the guarantee agreement could be held confidential.
Correct.
We've voted to do that in the past. I don't think we should change what we voted to do.
Agree.
My opinion is we should keep that confidential. That the bonds, if there's a bond, it should be confidential.
Well, that has not been voted on, so that
Well,
would
then
be
maybe
new.
I'll add that today. That the bond, if there's a bond, it should be confidential. If there's a letter of credit. Now, of course, a letter of credit's not actionable in a lawsuit. It seems to me that if you have a complaint against someone, you want to sue them, that part of your lawsuit process is to go through discovery, and part of that's to go through a subpoena. And I just don't think I think if we're either going to keep their financial information and their financial statement and their financial, I know what you're saying. Don't go there with me again. I think that this board's already ruled, and we have an informal opinion from the Attorney General that it's permissible to keep that confidential. And I think we should continue to do that. So if there's a motion required today, then my motion will be at the proper time, Mr. Chairman, that we continue with our current policy, that the guarantee agreement is confidential and a part of the financial statement in the broadest term, and that bonds and letters of credit be included as well. And that if the Attorney General rules against us, we can revisit it. But I just don't think that we need to change it. Now, I'll have to say this. The new forms that we're using that set an actual limit, dollar limit on it, sets it to expire in 2 years, and has them sign that we understand what we're doing and all the risk of it, I think that's great. And I think it's working well from the things that I've seen. So that's where I stand on the whole thing.
Any other comments from board members? Otherwise, I'm going to open it up to the floor.
I agree with it. I can't use some of those same words that Bill used, but I agree with the content of exactly what he said. You go to a lending institution and you have a letter and you have to sign a personal guarantee. That's part of your financial stability.
Well, when you do it through a lending institution, though, are you not securing the obligation to the lender not to the consumer, which in this case we voted that the intent behind them is to secure the obligation to the consumer.
It could be construed as both, depending on the lender.
I'm agreeing with Bill.
My only other suggestion would be that the board would request an Attorney General's opinion on it.
Why would we do that? I thought that's what we're here today, is to determine what we're going to do. Why are we being even asked to do anything?
I was just asked to create the report in March and give my recommendation.
I agree with Ronnie. I don't see why we should seek out a contrary opinion or even a confirmatory opinion. I think we should set our policy and let it stand. And let me just say this, as far as consumers concerned, consumers should understand that this board requires a certain level of financial responsibility and ability to get that license in the first place. There is that there through one of these 4 ways we've said it: assets already on hand, guarantee agreement, bond, or letter of credit. And it is there. So if they're involved in a lawsuit and if they need to find out how it's there, then they have the ability to subpoena and find it out. But I don't see why we should be in the business of letting what I think should be confidential financial information go out just on a website or for somebody to wander in the office and look at it.
We issue their license. They present us with a possibly an audit statement or a statement of their own, and we look at that and their license are given based on that information that we have. And I don't want the world looking at what I got.
Well, I'm not. I mean, I'm differentiating between the financial statement and the guarantee form.
Mr. Chairman, I move that we continue to consider the guarantee agreement part of the confidential financial statement in broadest application of the term, and that we also include bonds and letters of credit.
Second. Now we can talk about it.
We can have discussion on this matter now. You want to hear from the public?
Sure. They would like to say they agree. That's good.
All right. How are we going to do this, Jenny? Have you got a list of people that want to speak, or?
I would. Mr. Taylor, do you have any comments? Okay. On this, the only other person I don't think is here that I've spoke with personally Mr. Scarborough, I don't think he's here today. So unless there's somebody else, Mr. Taylor, you would probably be the first.
Thank you for the opportunity. My name is David Taylor. I'm a construction lawyer here in town with Bradley, Arant, Bolt, Cummings. But let me emphasize 2 things. I'm here on my own time. I'm not here representing any client. Let me also tell the board that I have both sued individuals under these guarantees, and I have also defended a number of clients who have been sued under these guarantees. And so in my capacity, I'm also currently the president of the Tennessee Construction Council and been a past chair of the Bar Association Construction Law Committee. So I say that not to somehow tout any particular credentials, but just to state that I feel I'm a part of the construction industry, and I've had a number of conversations with both Ms. Taylor and Ms. Lazenby and wrote a couple of letters to the board. 2 things and comments, especially on Mr. Mason's, your comments. Currently, I understand that the board is under an informal opinion from the Attorney General. I'd like to kind of reiterate Ms. Taylor's suggestions because there is such an unknown quantity to this. Before last year, the board said the guarantees were not confidential and anybody who wanted a copy could obtain a copy. That was the policy before. And there is a lot of question, I think, within the legal field as to whether or not the board can then, on its own, determine that a document that's been presented can all of a sudden be confidential. So I do think, and that's why the Attorney General is there, is that it will be very helpful to everyone, the construction industry, the licensees, consumers who may rely upon these guarantees, to obtain an official opinion from the Attorney General's office as to whether or not these guarantees or lines of credit or bonds are in fact confidential. The other point that I wanted to make is, while I understand the board's present policy is absent a subpoena, these guarantees or lines of credit will not be made available. It's my understanding that the board doesn't fight the subpoenas. They've just said you have to get a subpoena. My only issue with that, with all due respect, is that you can't get a subpoena without filing a lawsuit or filing a demand for an arbitration. Many times in advising my clients on the homeowner side or from the owner side, a decision as to whether or not you decide to make the big step and file a lawsuit or demand an arbitration, there are a lot of things that go into that. A lot of things also to go into is whether or not, at the end of the day, if you want to spend the time and the money and the effort to do that, whether or not there may or may not be anything to get at the end of the rainbow, so to speak, if you're successful. Since the board has decided that the entire purpose of these guarantees is for the consumers, to protect the consumers, by the board making the decision that these are confidential and you can only get them from the consumer standpoint if you have a subpoena, what the board is doing is, in all due respect, encouraging litigation. I've got a claim right now with a homeowner, a contractor who after 2 years said, I'm done. I'm shutting down my business and I'm done. Maybe they're about 75% through. And it's a licensee. We may or may not file a complaint. We'll just have to see. But in advising my client, and especially if this entity, this corporation is shutting down, the odds are they're not shutting down because they've got a whole lot of assets. They're shutting down for probably very legitimate reasons. They don't have any work and they just made the decision to move on. The problem in advising my client is that I have to say, well, there may or may not be a personal guarantee, we don't know, but the board and its wonderful staff won't even tell us if there is a guarantee without a subpoena, and then we can't get a copy of it without a subpoena, which means that we actually have to file a lawsuit or spend tens of thousands of dollars sometime in arbitration expenses in order to even get the right to get a subpoena issued and served on the board. And so I don't like coming before boards and just complaining. I like to make suggestions. My first suggestion, as I mentioned, is to get an official opinion from the Attorney General's office. The second thing that I would suggest, if somehow there's an in-between, is first to be able to at least have the board staff let somebody who requests know if in fact there is a guarantee or bond or letter of credit. If that person then chooses to file a lawsuit to get a subpoena, they can. The second alternative that I can think of would be to at least have a policy where the licensee gets notified if in fact there has been a request for a guarantee. But I think my main point, and I appreciate the opportunity and I'll step down, is that I do think it would be very helpful to get an official Attorney General's opinion on this particular issue, because there's lots of thinking on both sides as to whether or not the board has the authority to do that. And then secondly, just to make sure the board understands that by making the policy that these guarantees that are geared towards protecting the consumers are only available upon subpoena, the board is encouraging litigation and the filing of legal claims. And as everyone who's been involved in that before, once you start a legal claim, you never know what you're going to get back. And many times in advising my clients, many times folks decide not to start any legal action, but if it's a situation where they see that a company is shut down or it's an LLC, a limited liability company, the only way they can find out if there's a personal guarantee or a line of credit is to start a lawsuit. Thank you for your time.
Thank you, Mr. Taylor. Come.
Thank you, Mr. Chairman. I'm John Williams. I represent the Home Builders Association of Tennessee, and I have spoken to the board on previous occasions concerning guarantee agreements. I want to say, first of all, that we really appreciate the time and attention that the board has given to this issue now over a period of, I guess, a little more than a year. There have been some disagreements that the association has had with the board, but there's been agreements on a number of issues, and I think overall the association is very pleased with where we are now. We didn't get everything we wanted, but we got some of the concerns that we had addressed, and addressed in a way that I think we're completely satisfied with. We would like to see things stand where they currently stand. If I could address two of the points that Mr. Taylor made. First of all, although the board has the authority to request an Attorney General's opinion, in my experience, and I've appeared before a number of boards on a number of different issues, generally an opinion is requested only when the board is divided or has some real questions about the interpretation of a particular statute. I don't sense that the board has questions or has differences of opinion about the statute that the General Assembly has passed, which clearly says that a financial statement submitted to the board for the purpose of determining a contractor's monetary limitation, how that should be applied to guarantee agreements and to bonds and to lines of credit. And I think the General Assembly has spoken pretty clearly and said that type of financial information shall remain confidential. It's not subject to the Public Records Act. And so I don't think that it's really appropriate to request an Attorney General's opinion unless y'all are in doubt or have a difference of opinion. And I would say further that there's a joke in the legal community about Attorney General's opinions. They don't really settle anything. Those who like an Attorney General's opinion say, well, that's the opinion of the Attorney General. Those who don't like it say, well, that's just one lawyer's opinion. And that's true. In a lawsuit, the Attorney General may have an opinion and a private party's attorney may have an opinion. It's the courts that settle the question of interpretations of statutes. And maybe someday this issue is going to come up in an appropriate court in an appropriate case, and that issue is going to get settled by a judge or by an appellate court. But getting the Attorney General's opinion is not going to be a guarantee of what the correct interpretation of the statute is. So I just don't know that that's really something the board needs to do. And with respect to getting the records, as has been said, with a subpoena, a party in a lawsuit can obtain those records. It's not like they're closed forever. And if a party believes that he or she's been grieved and that there's merit to filing a lawsuit, the cost of filing a lawsuit in a court in Tennessee is somewhere between $200 and $300. It's not tens of thousands of dollars. And once the lawsuit's been filed, a subpoena can be issued. And the thing that the builders like about requiring a party to have a subpoena issued is that that provides an opportunity for, in an appropriate case, a request for a protective order, so that this information isn't going to be, circulated willy-nilly. A court will decide. I mean, it may be that the builder's not going to request a protective order. Sometimes they may, but it provides that type of forum. And so it seems to me that's the appropriate way for a party that believes that they've been grieved and that their lawsuit has merit to get these records is by the issuance of a subpoena. So I guess the bottom line is we would ask that the board leave things the way they are for now, and you can always revisit it at a future time. But I think things have been properly decided by the board, and we would ask them to leave them as they are. Thank you.
Any other discussion by the board members?
I would like a vote on whether I can present a rule at the next meeting on guarantees. We need one.
Changes that we've made to the guarantee policy?
Well, just to start back the process that I had started, or we had started last year. That rule was withdrawn because of all the issues, but now that we've fleshed it out, I would suggest we promulgate a rule.
Why do we need a rule?
Because with licensing requirements, you need a rule. Policies are really not meant to govern this type of process. It needs a rule. And there's nothing in the law as written. I mean, the law says the board may draft rules to govern monetary limitation requirements.
Why don't we vote on the motion before the floor?
Okay.
We have a motion.
Okay, with no more discussion, let's vote. All in favor of the motion from Mr. Mason that guarantee agreements not be,
Go roll call. Roll.
we'll do a roll call, that the guarantee agreements are not public information and
I
remain
think it included
confidential.
bonds and letters of credit too.
Correct. All
The
right,
motion is stated.
Ronnie Tickle, aye.
Ernest Owens,
Aye.
Bill Mason,
Aye.
Keith Whittington,
Aye.
Reese Smith,
Aye.
Cindy DeBusk,
Aye.
Marvin Sandrell,
Aye.
and Mark Brady.
aye.
Okay, that's it.
Okay. Any discussion on whether or not we should have a rule-making?
Well, it won't be a rulemaking next time. It would just be me drafting it, putting it in front of you.
What would the rules say, roughly?
Well, it would just say all that we've decided, that guarantees are used in these situations. They may be used. I mean, the rule back in March 2012 just set out when the board requires them, when the board allows them to be used to help people out, and then of course I'd probably also add some of this that we've discussed today.
Okay, Jenny, go ahead and prepare that for the next meeting. I think that'll be fine. Jenny made a recommendation that we get an Attorney General's opinion on our decision that we just made. Anybody want to do that? Okay. All right, I think that wraps up everything on the bonds and guarantees.
And do we need a vote for the stamp, or just leave it as is?
What the stamp
Yeah, if I could,
says.
just
Okay.
that it will just state the date the guarantee was signed and then the date that the license expired.
Okay, someone want to make that
So
motion?
moved.
Moved and seconded. Any discussion? All in favor, say aye, please.
Aye.
Any opposed? Motion carries. Next item on the agenda is the May board meeting transcript. Take a motion for approval or any corrections.
Not have it available yet, so we're going to table that till the next meeting.
All right, we'll table that for the next meeting when it's published. I'm sorry.
Well, in fact, I
couldn't help it.
I would like to talk to you after the meeting about it. Just you and me.
I offered to type it up.
Okay.
Yeah.
Okay.
Sorry.
The next item is the interviewed and waived contractor and home improvement applicants. Any discussion on the interviewed?
I have two. This morning, this is applicant number 67007. I believe the company name is CSM Group, Inc. One of the principals of the company does have a felony. He has completed about half of his 5-year probation. They are a commercial contractor only. They are actually a construction manager. This was a vehicular homicide felony, and I would move that we approve their application for a license.
Second.
Okay, any discussion on that? vote for approval?
We just do them all at one time.
We can do that until we get one that's not looking like it's going to get approved. You have another one, Reese?
I have another one on Civil Constructors of Tennessee, LLC. It's a second license. We asked them to come in because there were some extenuating circumstances, a complaint on file which is being handled in the courts by arbitration and mandatory arbitration, and I move that we grant their license. That's applicant number 66972.
Okay. Any other interviewed candidates that we need to discuss before approving the whole list?
I've got a bunch.
All right. Go ahead, Ronnie.
We have Marco Investments. Number is 67009. Felony was in 1999 of cocaine. He had a license and it expired in 2004. He has since
Anybody have any? Okay. Well, we'll put him in the list with everybody else here.
Yes, 07113. This is a gentleman that has asked for an increase in his license to an unlimited license. But he contracted to do a job, and it had to have masonry work done on the job. And to do the work, the job was over $100,000. Turns around and he asked another subcontractor to do the work, which is fine because he's a general. But the kick is that whoever got the job was supposed to have a license. Well, the party that he gave the job to asked another guy to do the work, and he doesn't have his license. Now, gentleman, I think really understands that neither party had a license. And the job was for $116,000. I think, personally, the company itself, K-Bar Group LLC, ought to have some type of fine. I don't have a problem issuing him an upgrading license because he has a monetary wherefore to do that. But, and I talked to him about what he did, and he understands that what he did was wrong. But it sounded like it was a friend of a friend and on down, and he's looking for a fine from us, but a problem of issuing an unlimited license. Done quite a bit of work in the I think the biggest thing, more than anything, he needs an unlimited license to bid on a veterans hospital that's probably going to be built, and then you've got something here in Nashville, I think, hard something that's is his own way. I think he would like the opportunity to bid. He knows he can't bid because his license. Now, he does know he cannot bid until he gets a license raised. I would like to make a recommendation that we do give him his unlimited license.
What's the violation now?
I think it said he hired an unlicensed masonry subcontractor to do a job over 100,000 masonry job.
And I think, in my opinion, he knew he did wrong. So I would like to fine him for doing that.
How much?
I like $5,000.
What was the total?
How much? How much?
$5,000. I'm telling you, he knows he did wrong.
What was the total?
I thought you said 100,000.
Oh, well, that would have been all right too.
What was the total cost of the job?
$114,000 is what that's just masonry.
But he's the general for the entire job?
Yeah.
And how much was that?
It doesn't say, but it must have been a whopper.
So it's over limits, fine,
Yeah.
or without a license, which is it?
I'm sorry, what
He
now?
hired an unlicensed subcontractor.
Hired an unlicensed.
So it's misconduct.
Yeah,
to do
misconduct.
masonry.
I would think, from what I remember, 5 is probably high, but
That's all right. I mean, y'all asked me what I thought.
Yeah.
So, I mean, I'll yield for an amendment if somebody wants to do that, but what everybody wants to do.
He's going to get an unlimited license now.
Yes. Diddy, what would you like to do? You have that look in your eye.
I'm listening.
I'll agree with Ronnie. He's wanting unlimited license now.
That's Ronnie's recommendation. I'm fine with it.
Okay, we'll move right along to the next one. The next one is Faith Construction. The number is 67010. Another felony, 1989. He had a controlled substance. Taking the exam. He had a license expired in 2009. He again has taken the exam and passed. And very nice gentleman. And he's been $785,000. Faith Construction Group, LLC. $53553. Go back on this one right now until I figure out what this is about, okay?
Marvin, did you have?
Ron, what about Gardner?
Okay, I'll do Gardner. We had a gentleman came in, and I don't have it in front of me, but
The one you give me?
no. This was a gentleman. He and his wife came in. The name was Gardner. He does a lot of work. It appears for General Foods or something like that.
Yeah, General Mills.
He was asked to give an estimate on what it would cost to do a job. We have 3 letters. My first thought was that he actually bid on the job, but he really didn't bid on the job. He used the word bid instead of budget. And as soon as he found out that the job was going to be over his limit, he told him that, look, I'd love to do it, but I can't until I get my limit raised. So he did not bid on the job at all. Jenny, did he want his limit raised?
Yeah, I think he filed for an increase, and I just wanted your recommendation that the complaint against him be closed as well.
There is no complaint, it's just misunderstanding on our part in relation to what went on. And Bill took it first, and when Bill was listening to it, sounded guilty until Bill passed the ball. And
I wasn't sure.
You wasn't sure.
In fact, let me raise this too. I wondered if we even should have opened a complaint at all. And I asked the question, I think, to police, and before Jenny got over there. I hate for this guy to have a record that says he's had a complaint opened, and I'm not sure it should have been opened in the first place. I mean, what's our policy on that? If we just close it, then it always shows that he's got a complaint, right?
Well, on legal reports, I would normally say if he had a subsequent complaint, I would say he's had one closed and it was dismissed with no action. That's what I would tell you on the front end. Then if you ask for more information, I would say these details.
Doesn't the public get to see that there's been one complaint on this guy?
Yeah, if they requested it.
I would like to ask.
But they can see the file. I mean, they could see his application file without the complaint.
Sponge that, because this guy was really innocent. I mean, it was
All right, it's a public record. It's a public record. I mean, staff, as far as I know, the policy is, when somebody fills out an application and has somewhere where they admit a violation, they open a complaint, and then it comes to me. I mean, I don't know how to edit that.
I told him he didn't have a complaint as far as I was concerned.
Well, right, he won't after y'all vote to close it. That's all I wanted. He won't have. It'll be closed, but it'll still be a public.
Try not to bring it up, so we wouldn't have to worry about it.
Well, it'll have to be on my legal report at some time to get it closed. Yeah.
Filed the complaint.
Staff opened it based on him stating I violated the law. I mean, he sent a letter in that said I bid, and then he sent another letter that said I didn't bid. So.
All right, so we're recommending approval of his license. Okay.
And Jenny, didn't he want to raise his limit to an unlimited? I don't have the file.
I don't either. Kathy,
can you? I'd like to make a motion that we raised to 1.5 million. But what was it now? 1.4? 300,000. Yeah. His income financial statement shows that it warrants to get to $1.5 million. I'd like to raise that too.
All right. Marvin?
Okay. I don't really understand all this one here, and I think these people are here that trying to get a license, and maybe they can come up and explain a little better. It's Rosselli, is that construction?
Mike Fassbinder, I'm Vice President of Operations for Rosselli Construction Company. It's located in Columbus, Ohio. We filed an application for a contractor's license in Tennessee. It's sort of like your gentleman. We provided an estimate to a client that we put in our format that said it was a bid. We have a national account with a company in Columbus called National Church Residence. They do permanent supportive housing all over the United States. We have a master contract agreement with them for renovations and upgrades to 75 of their facilities in 17 states. There happens to be a facility in Tennessee. We provided an estimate for that facility in August of 2012. It goes into HUD for refinancing approval. We don't know when the project is going to start until it gets through the HUD process. 3 months ago, the client came to us and said it appears that we're going towards closing. You need to get prepared for this project. We filed with the Secretary of State the authorization, the authority to do work in the state. We took the test for the license. We passed the test. We submitted, and when we submitted, we put in the submission form that we had provided a bid for that project. It's an estimate, it's a bid, it's however you want to construe it. We do not have a contract for that project. We do not have contracts until the project has closed with HUD. Then we do an affiliate agreement with the local project in the state that we're in, which this one happens to be in Boulevard, Tennessee. So that's the whole history behind this. We use local workforces when we're in the market area to do this work. It was very small-scale renovation in existing facilities, bringing up some of the units to comply with ADA, doing some lobby upgrades. It depends on the project, depends on the location in the United States.
I didn't understand. I believe you told me that you don't have a contract on that job until it's over with.
We do not have a contract with the affiliate until the project has closed with HUD for financing. Once the financing is closed with HUD and National Church Residents, then we enter into what is called an affiliate agreement with the local facility to perform the work. We have a master agreement with the parent organization in Columbus.
Do you plan on doing this work in Bolivar?
We're going to provide a superintendent. We typically get local trades to do the work for us.
Off the cuff, I don't think it is the same as Ronnie's. I mean, I think they bid or offer.
I agree. What was the amount of your estimate for the project in Tennessee?
That project originally started out about $250,000. It's now down to about $35,000 because HUD constantly goes back and cuts things from the project. So we're talking about $35,000 worth of work on this project. But again,
the original estimate was $250,000.
That's correct, based on the original scope of work that was requested by the client for that project. Then it goes into HUD for their approval on what they will allow to go through the refinance process.
Offer to engage.
Yeah, you different. Y'all actually bid. That's the difference between.
But we have a master agreement with this client.
I understand. I understand.
No, I don't disagree with you. We have that master
Construed as a
agreement.
budget for financing.
They should have had Tennessee license.
Bid for work in Tennessee for $250,000.
What does Bolivar have? Do they have? What's the rule in Bolivar? Is there
an architect involved?
Yes. He is licensed in Tennessee.
have to have a license in Bolivar to build?
Yeah.
What we've typically done, and again, it's an oversight on our part of not seeing the requirement of having the license prior to providing a number. We typically have gone into the states once we knew the projects were going forward, taken the license or done these authorities to do work and engaged at that point in time prior to the work. It's been our typical method of operation across the United States.
Have other facilities in Tennessee?
They do have other facilities, but they're not in this part of this renovation project.
Y'all have other facilities here in the state of Tennessee?
They do, but we're not engaged in doing those.
Y'all engaged in doing anything if that happened?
Only if we had the right to do so. But that's not part of this program at this point in time, and that program has not been expanded.
A license here in the state of Tennessee and all these other... I'll get a license in each state you go to?
If the state requires the license, yes.
Have an application. That's the reason he's here. He's applied for a license.
I applied for the license, and then we got the letter to come for the interview. At that point in time, when we applied for the license, we realized that we had provided an estimate, we had provided a budget. We wrote a letter to that effect as to why we had done it. We were asked to come down for the interview, which we have done so.
So,
Is there any reason not to grant him a license other than this?
other than this, I would say, but I feel like that he was involved in really bidding or estimate without a license?
But I think just to move it along, I think we would grant him a license, but it would be with the 6 months
Waiting period.
and then he cannot. It's just a $35,000 job now. He's probably not even looking for that, and then he can't do this job.
But it was a $250,000 bid. So, yeah,
Start
I mean,
with.
whatever it is now is kind of almost irrelevant.
Right.
I think we need to
I
find.
think our policy or our rule is you can't do this job no matter what.
Right.
Forever.
He can't do this job. You're right, Reese. I think that's right.
Do you think he should have a fine for bidding without a license?
Well, I go both ways on that. If he's not going to be allowed to ever do the job, that could be a good fine.
But you're telling me that I cannot do this project in the state of Tennessee because I answered honestly on the form that we provided a budget for financing for this project?
No, sir.
You could have answered dishonestly too, but
No, I
and
would
still
not
not
do
been
that.
able
We
to
would
do
not
it.
do that.
Yeah.
I'm just asking that
That's
question.
that's our rule.
Okay, I'm just asking the question.
It's not because you answered honestly. It's because you bid without a license.
I understand that, and it was an oversight on our part. We provided these budgets a year ago for these clients.
I just want to make
Across
it
the
clear
United
that
States.
this board doesn't fine people or impose civil penalties for answering honestly. We impose penalties for violating the rules.
We understand that, sir.
I would say not getting the job is it would be the fine. Yes. Now, what I would suggest is y'all go ahead and get your license where you'll have a license here in the state of Tennessee if another job is afforded you. That's probably what you.
But holding the license for 6 months.
The law doesn't require you to do that anymore, but you still have that option. I just want to remind you about that change. The law changed, and you no longer have to hold it for 6 months.
But we can.
But you
We
can.
but if he got a job here and he wanted to come back to us, we could.
No, what we're doing right now, Ronnie, is
No,
we're going
okay.
ahead and granting his license with it being held for 6 months.
Okay.
But he cannot participate on this particular project.
I understand.
I'd like to handle this as a separate motion, so, do you want to make a motion, Marvin? Or adopt what Keith's motion just was?
Yeah, pretty well what he said, hold it for, give him a license, but hold it for 6 months and not let him participate in this job.
Don't have a current motion on the floor.
We're just discussing the interviews right
Applicants.
now. We hadn't had a blanket motion on them yet, Cindy, so we can vote on this one separately.
Okay, I need a second.
Second.
Any further discussion? All in favor, say aye.
Aye.
Opposed? Okay, that motion carries.
I have two. One is.
Wait, hold on, Ernest. Are you done, Marvin?
Got 2 or 3 more.
Okay, let's let Marvin go through his.
I have one here that they have a felony. Let me be sure I'm right. His license ran out.
Did have a contractor's license.
Right. And he's still on probation for a felony. Had a probation for having a wreck and got him.
That's the Conway.
License expired about 4 or 5 years ago. Was that right? and now you're wanting to try to get a new license.
Correct.
And you're on probation ever since 2010 now. You're like,
I've been on probation since 2012. I didn't go on the charge I was given. It was given to me originally in 2010, but they didn't. It was in question whether they were ever actually going to charge me because of the circumstances. And when they finally did, it took over a year for it to actually have for it. And what they did, they just ended up putting me on a 2 to 3 year probation. And even though I'm charged with a felony, but the reason they gave me the shortest probation, it was in the state of Texas. They gave me the shortest probation because of the circumstances. And what it is, if you're in a vehicle in Texas, if you're in a vehicle with someone and they're charged with a crime, anyone that's in that vehicle is charged with the same crime. And what it is that the individual who was actually pled guilty to the whole situation explained to them that he was just actually riding home with me from a job that we were doing in Texas, and due to the circumstances, I still had to be charged with the same crime, but I wasn't given any type of sentence like what the actual person was.
What was the charge?
He had 5 pounds of marijuana inside of his luggage as we were coming home.
What type of license are you seeking?
A home improvement.
Home improvement.
Yes.
What's your recommendation, Marvin?
and how long ago has this been?
2010.
10. Still on probation? I don't.
Till basically till this time next year.
It's hard to me, this is just my, it's hard to give a person a license that's still on probation. And it hadn't been very long. If it's been 10 years ago, 15 years ago, it's a little different. But when you had, it's only been since 2012. Still got another year to go.
Honestly, had not it been for the circumstances, if it wasn't for the question as far as with the DA in Texas as to whether I should actually have been being charged with it, if I had actually started the court process when the charge actually occurred, the probation would have been already been over a year ago.
How are you making a living now?
Just working in construction.
Working for other people?
Yeah.
You still have the opportunity to do that?
I mean, not to the capacity I should be, but yes. Honestly, the situation I'm in now, that I do know I know a lot of contractors because I've been in the business for so long, and a lot of several of them are aware of the fact that I have my license and I don't anymore. And honestly, I feel like many times because of that, I feel like I kind of get taken advantage of because of the fact that they know I can't do certain jobs. And that they can basically get these jobs, put me on them and collect all the benefits of the jobs.
So when does your probation expire?
My probation would expire June of next year.
Less than a year from now.
Right.
The charge was in Texas, and the one in Louisiana, was it?
That's not a felony. I looked at to see what that was. That wasn't a felony.
What is that?
It shows that it was a felony for 400 grams of cocaine.
Charged in Louisiana?
Not with that.
What were you charged with?
What were you charged with in Louisiana?
There was a cocaine possession in Louisiana. And if you notice, is Kathy? Remember when I sent you the email, I was explaining that I wasn't sure how that was exactly how that was showing up or what exactly the situation was with that. And that's why I wasn't sure exactly what to say about it.
What we have here is a travel permit signed by your parole or probation officer in June of this year, reflecting.
Last year?
Yes, last year, June of 2012, and it reflects that the charge she just stated, and that you would be on probation for that for 3 years.
That charge, right, as far as that one went, it was in conjunction with as far as the situation in Texas, and what they had done was when I was going to court for both of those at the same time, and they had told me basically that whatever Texas decided, that they were going to, they would roll it into that whole thing to where I wasn't going to have a probation from 2 states. It was.
I mean, if the board has more questions, you can either do whatever you want to do with the license application, but you may want more information on that charge. But for what I have in front of me, it does look like there was a felony in Louisiana, but I can't say he's not telling the truth. I've just got what I've got in front of me.
Right. I tried to get the information on that, and that's why when I sent the email a while ago saying I have no idea how that's actually coming, how it's actually showing up.
You probably just need to get a background check, pay for a background check.
Okay.
Mr. Chairman, we've in the past only rarely allowed a license when someone's on probation, and I think that it's not like we're going to be denying him the opportunity to make a living, because he's been able to do it already. And Marvin has already suggested it's his case, and I won't put his words in his mouth, but he said he was reluctant to give a license to somebody on probation. And I would suggest that we invite him after he's completed all probations to reapply, and at that time provide us a complete record of what went on in Louisiana as well as Texas for us to make a judgment on his past felonies.
Sounds good to me.
I move. That's my motion.
All in favor?
Aye.
Any opposed? Motion carries.
So what, reapply like this time next year?
Probation is done.
Probation, you got about 10 months, applying about 10 months.
Marvin?
I got another one here with Mr. James White. I think he's here. And he has several felonies. I don't think none of them here lately, but he can probably tell us what it's, when's the last one he had and what it was about.
My last felony was actually 2009 to 2010. Okay, I got out of prison November 1st of 2006. However, since I've been out of prison, I found Christ. I started my business with faith, $25, and a broken down lawnmower. And from that point, okay, let's define the word rehabilitation. Rehabilitation means change, fixed up, improve, made good, mend, rebuilding, reclaiming, recondition, reconstruction, reform, refurbish, rejuvenate, renew, restore. Okay, and regret, I regret my past actions for what I've done. However, I can't take that back. That's my past. Past meaning past tense. However, if we will, focus on my present accomplishments since I've been out of prison. Okay, I started with my own business, $25 faith, and a broken down lawnmower. I turned it over $63,000 in assets. I have my voter's registration rights restored. I am certified, licensed, and bonded. And I'm current on my child support, and I have letters of recommendation from chief of police, clients, my ministers, and people that I've done work for in the past. So all I'm asking, if you would judge me on my present accomplishments instead of my past. All I have to say.
Are you currently on probation of any
No,
type?
I haven't been on probation since 2009. I got my voter registration rights restored in 2009, so I do vote.
Good for you.
I have, I'm current on my child support. I don't owe no arrears. I'm a father to my son. I'm a pillar in my community. Ma'am,
What were the charges?
the last charge was aggravated robbery. And then I have small drug charges.
When was that, the last one?
The last one was 2009. And I got off probation, parole 2009.
Charged in 2009.
I was charged 2000, and I got out of prison November 1st of 2006. So from 2006 to 2013, I've had my own house built from the ground up. You know, I didn't ask for a handout. I started with $25 in a broken down lawnmower.
But the crime was in 2000.
Yes, that's correct.
And then you served prison until 2006, and then you did
That's
probation
when I got
until
out.
2009.
Sir?
And then were on probation until 2009.
Yes. Then
No
I got my
trouble
voter
since then.
registration rights restored.
No brush with the law since then.
No. No more than a speeding ticket.
What license is he applying for, sir?
LLC.
What's your recommendation?
Licensed residential, 70,000.
This is home improvement, right?
Ma'am? Yes, ma'am.
Home improvement license application.
Also have a letter of recommendation from
approval, ma'am.
clients.
What do you think, Cindy? Yeah, I recommend him. Okay. I recommend getting him licensing.
Second.
Well, let's vote on him when we vote on the other approvals.
Okay. Let me see.
Got another one?
We're going to vote on your license approval here in a minute when we vote on all the other interviewed applicants.
Thank you for
Thank
taking
you.
your time.
I think we got a Mr. Bruce Anthony Baldwin. I'm understanding right, you got a felony, but it's been a while back, you went to sleep or something in the car and hit somebody and
Bill is in 1987.
87.
You on probation now of any type?
Oh, I got a 2-year sentence, and I've not been on. It was over in 2009 or 89, 1989.
Been a long time, yeah. I recommend we give him his license.
Anybody else got?
I have two.
Okay.
I didn't interview these individuals, but one of them's Carol Holmes, and he was asking Holmes, not Holmes, Homes. Okay. He was asking for approved BCB for $750,000 make BCA unlimited. But I haven't seen any financials on him, and I couldn't really act on this. I don't know whether Ronnie interviewed him or not. I did not interview him. I don't know whether he's here or not.
I don't understand why they would have given it to you with no financials.
It was handed to me, and off to Ernest.
So was he interviewed today or not?
No, it was shipped to me in Memphis, and I sent it back up here and said that I needed some help.
I was next door to
He
him.
was next door, so I think that was tough for both of us.
Let's try and get through these interviewed applicants first.
Okay, I would recommend if If he has the,
Well, he's not on this list, Ernest. Let's just do the interviewed ones first, and then we'll get to that one here in a minute. Is there anyone that you interviewed that you need to discuss with the board today?
I didn't interview anybody. That's what I'm
Okay.
saying. Ronnie gave them to me.
Okay, I think we are done with the interviews.
I've got 5.
Oh, okay.
Go real quick. 59754 Horizon Building Services, Mr. Toe. There's some questions about when his incorporation went out of business and he wanted to change his mode from a corporation to himself, and I just recommend we go ahead and approve that change of mode for him. 66939 Brogdon Construction limited license, approve him. 67087 Eccles Enterprises, he had a felony. He wanted a limited license, and he also had a felony. His felony involved 2 DUIs and a driving without a license in a short period of time, which in Tennessee at that time produced a felony. That was in 1999. He's doing okay since then. I reckon no probation currently, of course, and I approve him. On home improvement 7640 Floor U installation, did some work over limit in a home improvement county before he got his license. I recommended approval, but with a $250 civil penalty. And HI 7628 Screaming Eagle Construction also did work over the limit before applying for his license, and I recommended a $500 civil penalty.
Okay.
I've got 5. Home improvement number 7657. Bidding and performing work without a license. I recommend approval of the license, but with a $250 fine. License number 66571. Bidding without a license. This was a difficult case. Jenny sat in on it with me. They actually have a North Carolina license. They bid work to construct a church in Chattanooga area. When it became apparent that they needed to have a license, they engaged in conversations with the owner and another company. The other company subsequently got the job, but this company got hired to do the construction superintendent work. Was that?
All right, and I think I know you said it was a church. I think it was a commercial building related to the church. But anyway,
Okay.
yeah. I mean, it looked like they bid it, and then they realized that there was a problem with that, and now there is another company that they associate with who contracted with the owner directly and then hired them as the project manager, after the bid process.
At any rate, for bidding without a license, I'm going to go ahead and recommend that we give them their license, but we hold it for 6 months, and they got the job, so I'm recommending, basically they got the job, so I'm recommending a $5,000 fine for bidding without a license. License number 54382. This is Archer Plumbing. Another situation here, they bid over their limit. It was approximately a nearly $600,000 job that they bid on a $100,000 license. They did, in fact, get the job. They have applied for an increase, and I'm going to recommend we go ahead and give them the increase, but a $500 civil penalty to go along with that. That needs to be paid before they get that increase. License number 67055. Young man had a felony back in 2003. It was for some driving offenses, not securing a load properly. Then he didn't pay the fine. Then he got a couple more, and in the state of Florida, they must take that pretty serious because they gave him a felony for it. It's a $100,000 license, BCA. I recommend approval on that. License number 55042. This is really kind of technical, and I feel kind of bad about it, but it's part of our license, and he knew it and understood it, but he bid in a name other than what he was licensed for, and he's trying to work out a mode change, so we're going to do that, but agreed to a $250 civil penalty. And that's all I have.
Okay. It's everybody, I believe. I'll take a motion for approval with fines as mentioned by the board members that interviewed these applicants, for all interviewed applicants with the exception of the one that we previously voted not to renew.
Mr. Conway wants to address the board one more time.
Okay.
The situation is kind of hard to explain. I understand how, when you look at it on paper, what it's looking like, but also if you look at the two charges, what is put on there and the dates of them, I don't know if any of you know how much 400 grams of cocaine is, but that's why I'm saying I don't know how to show them, because if I was actually guilty of a charge like that, there's no way I'd actually be not in jail. I was some things that happened in Nashville around 2008, 2009 that I was asked to help with some things, and it put me in this situation. But the reason that the reason why I'm saying I don't know how to get I sent the email saying I don't know how to get the records is because the records on the situations are kind of sealed, that I don't actually have access to some of them. And so I can't really stand up here and explain everything because I really don't know how to. Not that anything that's on there would have changed, because if I would have known that it would have affected me, whether I could have got my license back or not, as far as the circumstances of everything, as far as that time period would have changed. But the reason why I brought the reference from the law enforcement agency that I did was because to show that I'm not, as far as what it's showing on paper, that I'm not actually that person that it appears to be.
Here's the thing. Nobody here wants to keep you from making a living. And the reason you were denied today, or will be in a minute, we've already denied you, we've already voted on yours, was because you're still on probation. You're going to be on probation until next year. Now, we want you, and I've asked you and invited you to reapply next year. And we want you to do that. And we want you to get your license. Well, when you do that, what you need to do is bring us whatever records you've got. If you can't get records, then you write a nice letter to us and explain what you can about it. All right? And we're gonna look at it again. Of course, you're going to stay out of trouble between now and then. And we'll be able to show that you have. And we'll be fair with you. I promise you we will. And I understand that records are hard to get. Things are hard to explain this much time in the past. But what happened, when you come to reapply, you give us a full explanation as you can. What you can get and what you can supply yourself, and you'll get a fair hearing. Nobody here wants to keep you from making a living. We don't want to keep you from having a business. We just have a policy that we just don't let people still on probation have a license. And So we're not singling you out. It's not just because it's you. It's because that's just the way we like to do things. And we have a responsibility when we let somebody go in someone's home to make sure that everything's as right as we can make it be. You understand that, I'm sure. So I understand what you're saying, but just, bring us, do what I say a year from now when you get ready to reapply. Give us the best explanation you have of what's happened to you in the past, and we'll be fair with you. I promise you that. Okay?
Okay.
Thank you, Bill. All right, we need a motion on the interviewed applicants.
Make a motion that we approve or accept the recommended board members' actions on any interviewed candidates.
Second?
Second.
Okay, any further discussion? Everybody understand what the motion is? All in favor, say aye.
Aye.
Any opposed? Motion carries. Ernest, you had one applicant over there that, I don't know if, is he on the waived applicant list?
On the waived.
Okay. Now would be a good time to bring that up.
I didn't, like I said, I didn't interview this individual, but he had asked for an approved BCB in the amount of $750,000 or make a BCA unlimited. I didn't see any documentation or letter of credit to warrant this. Couldn't make a decision what to do in that particular matter. I don't think Ronnie interviewed him. Did you interview him?
No, that was, I couldn't do it either, and that's, I had.
He gave it to
I'd
Mr.
asked-
Fowler.
It was my file. It was sent to me from Chris.
Is this the file?
Where's the file?
Here it is.
The recommendation to be to deny him a license?
We just need more explanation. I mean, it just didn't make any sense to me. I gave it to Ernest, and Ernest, here we got two of them, and I think Ernest felt the same way.
Can we table him, or?
They're adding class.
Oh, it's an ag class.
I'm sorry.
Okay.
And he wants to go.
They've got a license, they're just wanting to change it to a BCB.
Did he pass the exam?
Yeah.
Ag class. He already has a license, so he must have met the financials already.
Yeah. All they're wanting to do is go from a BCA to a BCB. And an unlimited.
Qualified before already.
Already has BCA Unlimited. He wants to add
That one right
B.
there, you just need to sign off on it. Give it back to Kathy.
All right.
And that was another one Ronnie gave me.
Those you just need to sign off on. You don't have to present them before the board.
I'll hear a motion for approval of the waived applicants.
I think you got a motion on the second.
Waived applicants, yes.
I move to approve the waived applicants.
Second.
Any discussion? All in favor, say aye.
Aye.
Motion carries. All right, next on the list is home improvement applicants, was that on the waived list?
Well, that's what we.
Okay, so we just approved waived and home improvement.
We need to do revisions, don't we?
We need to do revisions, correct. Should be name change, increases, combinations, mode changes.
They've already been mailed out to our members, and then I move for approval.
Second.
Any discussion? All in favor, say aye.
Aye.
Any opposed? Motion carries. Next item would be limited license electricians.
Make a motion that we approve the LLEs as
Approved. Okay, any discussion? All in favor, say aye.
Aye.
Any opposed? Motion carries. There is no LLPs to approve. That takes us to the legal report.
I need a break before the rulemaking. You have 10 minutes. We're not good.
Can we finish this and then go to rulemaking? And then we might be 10 minutes late on rulemaking.
Right. The residential and commercial subcommittees reviewed the legal report and made the following changes. On the residential portion, item number 4 was marked for discussion, and the subcommittee recommended closure with a voluntary surrender of the license. On item number 7, the subcommittee recommended a $3,000 penalty as opposed to a $2,000 penalty consent order, and a 1-year suspension as opposed to a 6-month suspension. Item number 14 was recommended for closure, and the subcommittee changed that to, on complaint number 1, $500 consent order for failure to cooperate with the investigator. Item number 45 was marked for discussion, and the subcommittee recommended closure as a civil issue. And item number 48 was marked for discussion, and the subcommittee recommended closure on that one. On the commercial portion of the legal report, item number 2 was marked for discussion, and the commercial subcommittee recommended closure. Item number 3 was marked for discussion, and that actually was one that we have handled in the discussion about the interviewed applicants, Roe Messner. And then item number 6, the subcommittee recommended a $1,000 consent order as opposed to a letter of warning. After the subcommittee met, I remembered...
Hold on, Jenny.
Sorry.
Item 6, we recommended a $1,000 penalty for respondent 1 and a letter for the third party.
I apologize. You're right. So, okay, item number 6 on the commercial portion was authorize a $1,000 consent order as to the respondent, and then authorize a letter of warning to the third-party contractor who was mentioned in the summary. I apologize.
Okay.
After the subcommittees met, I remembered that I had a 3-case addition to the legal report, which I've passed out to everybody. And you can disregard number 2. I'm going to get more information on that one. So basically it's just 2 cases, number 1 and number 3, and I can just shortly summarize them. The first one is a limited residential licensee, and the homeowner hired him to do a relatively small job, a $2,200 job, and he dug up a floor and left the concrete floor, or left it open for about 6 months, never came back. She paid him about half the contract price, and he just stopped coming around and wouldn't communicate with her, and so she finally had to hire a third party to complete it. And the inspector who went out looked at the pictures that she had of how he had left it and was of the opinion that it was grossly negligent. So the recommendation is a $500 consent order along with a formal hearing. And then item number 3 involves a residential contractor with a $1 million, $500,000 limit. He built a home for the complainant in 2007, and there's been a major issue with moisture intrusion.
You don't have to read all that.
Okay. The recommendation is $5,000 consent order with the authorization for a formal hearing.
Make a motion, we accept the legal report and the addendum to the legal report.
Second.
Any further discussion? All in favor, say aye.
Aye.
Any opposed? Motion carries. Keep going.
Yep.
Review of trade exams. Carolyn.
To review the rest of the trade exams. Another commercial and the business and law. And the residential trade was reviewed last year. And so we need, PSI has asked for us to go over the LLP, the LLE, the electrical, and the mechanical. So I just need you all to give me names of who you would like to be the subject matter experts. You can also be a subject matter expert and review the exam, and they're going to do it by webinar, so you don't have to travel. So I guess what I need for is just the board members to email me some names of some suggestions of who you want to use, and let me know whether or not you can participate. And of course, the dates that you're available.
Suggested dates to be when this is going to take place, or?
Yeah, let's see where they're at.
September, except for September 9th through 13th.
Linda Newman will be available to do it, but if none of those dates work for you, she can reschedule some more.
Send us all that email, Carolyn, and we can respond back. Department legislation.
We were asked to provide the department a wish list of legislation, and it was before the board met, so I couldn't get you all to support the list that I provided. And so this is a little bit after the fact, but I just want to get it on record of whether you have any objections to this type of legislation being drafted if they do decide to send it through. We do need legislation, I believe, to allow citations to be collected without it going to a formal hearing. Something like a parking ticket situation, and that was something. When we do issue citations, if they do not respond, then in order to close them, you have to have a formal hearing. And so we were looking for something to make it on the basis of like a parking ticket. Like you either respond or and appeal what the ruling was, but you always will be given a chance for a formal hearing if you don't want to settle.
What happens if you don't respond?
It would be,
you don't hear back from them.
It would be a non-contested case.
I mean, the way it's written now, it's just it's written so poorly. It's hard to tell if the intent was to allow us to collect on it without a hearing. That's just since I've been here on citations, they become nearly a waste of time because every once in a while they pay them and we close them out, but most of the time they ignore them and we have to move forward in the complaint process.
What are you looking at today from us? Just
Support on
support
whether
to proceed with filing
Well,
this
the-
with the legislature?
Yeah, the department has a package they submit every year, I think, to the legislature, and it just, from each board, on what kind of legislation we would want.
right, and
Is
this
that what you want, Carolyn?
that's what I would like.
Good enough.
I did, but I'll do it again.
It was part of the agenda that she sent this
She
past
did,
week.
she sent it to us. I even got it.
Twice.
You could email it to us again, Carolyn, and just ask for any comments from the board members.
And citations are only up to 1,000.
And this is unlicensed. And then we also want to ask for a budget improvement request to try and get some kind of enforcement. So we thought we would start out and ask for 3 inspectors to do policing. So I just wanted
How many do you really want to get?
10.
Then you need to ask for 10.
Just enforce some of this stuff. We see stuff going wrong. What?
Have now.
0.
Oh,
It'd be nice if the board could, if we see things are going wrong, if we could intervene and do that. We could stop a lot of
That'd be a
stuff.
conflict of interest, Ronnie.
I guess it depends on who.
Can't be the judge and the jury, though.
Did have them before.
have how many?
We did have 10.
Okay.
Ask for that again. I mean, don't ask for what you're willing to settle for. That's not how it works.
And then, and this is also part of what we had to go to a sunset review hearing last month, in May, and they looked at our budget and they wanted to know why we were sitting on all this money. So our reserve fund has built up, and they did make the suggestion that you need enforcement. You know, they were getting complaints as well that there was no enforcement out there, and especially the out of state coming in, the storm chasers, things like that. So
Let me say, too, even if it wasn't there, Carolyn did a great job representing this board at that hearing.
oh, thank you.
And we got a 6-year extension, and no other board that was there that day got nearly that much, and one of them didn't get any extension at all. So I really, we need to commend Carolyn. She did a wonderful job representing the board and what it does, and I think even one of the members said we were an excellent board, as I recall. So that was good to hear.
Thank you. And what else? Oh, another issue that came up and is expanding the home improvement law. Right now, it only applies to, well, the way we interpret it, that it only applies to 9 counties. And so, and one of the members of the legislature also said, you know, he agreed that it needed to be statewide. And so I put that on the wish list as well. But there was I think there's a legal opinion that it already applies statewide. So one of our attorneys has said, ask for an attorney general's opinion, because the way he reviews the law is that it already applies statewide. So,
Better way to go if we could. In this case, might be the good thing to do.
attorney general's opinion to see if it's already.
Because, you know, everybody's going to have parochial concerns in the legislature about, you know, my buddy ought not have to get a license. But we won't have to. It already applies statewide.
Do we need to vote on that?
I think move we ask for Attorney General's opinion on whether the home improvement statute should apply statewide.
Second.
Any other discussion? All in favor, say aye.
Aye.
Any opposed? Motion carries.
They need a roll call. They don't, do they? No. And let's see what else. Oh, and we also need a law that will allow an inspector to actually, if we ever got inspectors, to allow an inspector to issue a citation. Right now, it's been interpreted that only I can issue a citation, But I think the intent was that I could turn it over to an inspector. Right now, if we issue a citation, we'd have to put it in the mail to the contractor, so it doesn't work so well. That was another.
In addition to the list that you sent.
Right, and then and the last is merging the LLE, the limited license electrician, and the limited license plumber with contractors on budget-wise. We did that with home improvement. This way, there's one fund instead of 3 different funds. So that was something else we wanted to get your support on. But I'll email that list to you again.
That need to be voted on by the board as a support, or we?
I mean, I would just do maybe a final vote, just that you support all the things that she's summarized.
I make a motion that the board support the wish list of staff and make it part of our wish list for legislative action.
Any other discussion on that? All in favor, say aye.
Aye.
Any opposed? That motion carries.
And I guess it's time to go ahead and.
Last topic is the next board meeting, which is September 24th, 25th in East Tennessee.
Where do y'all want to go? Y'all want to go to Knoxville or Gatlinburg, where we went last year?
Gatlinburg.
Go back there if that's all right with everybody.
So,
Thursday was. That's a little question about going that far. That's fine.
take a motion for adjournment.
Until, for 10 minutes, we got to do rulemaking.
Second.
That part of our,
I might just want to make sure you remember.
I think we're done.
Okay.
let's adjourn and we'll take a 5-minute break and then we'll start the rule-making hearing.
Did we adjourn?
Second.
Adjourned.
You gonna eat today?
The table eating crackers.
Ready to eat what?
This,
Are you ready?
Yeah, thank you.
Big old hot dog would be good about right now.
That's good.
Did you hear me eating crackers over here under the tree?
Excuse me. No.
Cheaper anyway.
Unlimited.
oh, sorry.
There's nothing in it. I tell you, I'm thinking about
They should have given you financial, have this kind of question on it. They screwed up.
I don't understand.
We'll be over in 30 minutes.
On in the States. So I'm not hungry, so I don't. Yeah,
Good. I like it.
But you gotta make sure you're getting enough.
Well, I think I agree with that.
Pretty
That-
pretty.
This whole thing is not just a
And so I, you know, I looked at it and I said, well, I just can't, I don't know what to do. So I was dealing with that other one, so I said, I asked her, I said, you look and see if you can fix it.
Yeah, I know this baby. I know this.
She may have.
She already signed up.
Okay.
We already signed up.
Well, we usually have everything in here, bring everything in.
Oh, I see. He's already got unlimited on A.
Yeah.
And he's got a 750,000 on B small. So their question is, on the BCB, should it be $750,000 or unlimited?
But we didn't have a financial statement to
We don't.
justify anything.
We don't know. We know. Well, we know he has a financial
list?
statement already for A.
Notice of the rulemaking hearing.
My name is Jenny Taylor, and I serve as staff attorney for the Department of Commerce and Insurance. It's July 30th, 1 p.m., and this rulemaking hearing is taking place pursuant to Tennessee Code Annotated Section Title 4, Chapter 5, Section 204, and Room 1A of the Davy Crockett Tower, 500 James Robertson Parkway, Nashville, Tennessee. The purpose of this rulemaking hearing is to solicit comments on proposed rules the Tennessee Board for Licensing Contractors has made public in order to make licensing changes and clarifications, and to amend language in the existing rule regarding misconduct. A rule is defined as an agency statement of general applicability that implements or prescribes law or policy or describes the procedures or practice requirements of the agency. Proposed rules are filed with the Office of the Secretary of State, notice is given to the public for comment, and a rulemaking hearing is held. Upon conclusion of the hearing and adoption of the proposed rules, the rules are forwarded to the AG's office for review of legality. If approved, they are filed with the Secretary of State, which is responsible for publication, and the Government Operations Committee of the General Assembly. The rules must stay in the Secretary of State's office for 90 days, the end of which time will be the effective date. Those members of the public wishing to speak should sign up at the table at the front of the room. Only those who have signed will be permitted to speak. The notice of rulemaking hearing included the entire text of the proposed rules and was published with the Secretary of State, Division of Publications, on May 29, 2013. Additional notice was given by the Executive Director of the Board, Carolyn Lazenby, by email sent to all licensed contractors and persons who have provided the Board an email address and requested updates on new or amended statutes, new or updated rules, changes to fees, rulemaking hearings related to fees, significant changes impacting your license, changes to policies within the Department. Another notification was sent to all persons who elected pursuant to TCA 43-1306 Section D to receive notification by email of certain changes or potential changes to the laws applicable to their profession. I will read each rule as amended or new rule into the record, and comments will be permitted afterwards. After comments are made, the Board will take a roll call vote on whether to approve the rule or not with any amended changes. Okay.
Reading, you're going fast.
Sorry. At the conclusion of the reading of the rules and public comments, the Board will discuss any economic impact the rules may have and whether the rules are expected to have any impact on local governments. Each comment must be addressed, including a statement of reason for agency adoption or rejection of specific changes suggested by the comment, although similar comments may be grouped together and addressed in one response. If no comments are received, the rulemaking hearing rules must still contain a note reflecting that. At this time, I'm going to...
Okay.
Okay. At this time, I'm going to read the notice of rulemaking hearing proposed rules. And the first one is Chapter 0680-01-.16, which is Appendix A of Rule 0680-01-.12 classification system, is amended by deleting Section 1, Limited Residential, under Paragraph A, and by substituting the following language so that as amended the new section shall read as follows. A limited residential contractor is authorized to bid on and contract for the construction, remodel, repair, or improvement of a single-family dwelling, the total cost of which does not exceed $125,000. Authority TCA Sections 62.6.108 and 62.6.112. And if there are any public comments on that one, now would be the appropriate time.
We just have one comment. I've done a little research on the little residential license, and in speaking with some codes departments, a couple of the codes directors have some concern about the interpretation by the codes department on how to enforce this rule, and what we would suggest. Well, it is our understanding that the rule also includes the cost of the lot if they're building a home, but that is not clear in the rule. We would suggest in number 1 of Rule 0680-01-.16 that we add the words including any lot cost behind total cost, so that is made clear and they know to include the lot cost in that, and also to add it in the next rule at the bottom, 0680-01-.29.
And any other part of the?
Well, if I could suggest to the board that what she's referencing could be handled in one of the major parts of the, we could do a rule that would apply generally to all the licenses and not just this one.
I thought it was
My
already,
understanding is it's only this license that includes the lot cost as well. It's not a general contractor's license. It's only the limited license.
That's not in the law anywhere, so I can't respond. That might have been a board policy, but it's not in the rules. So, it's up to the board how they want to respond to that.
well, the word total cost includes the land. And I think ever since we've had the little R, that was the intent by the word total, was total cost,
Actually, I believe it was discussed at the last board meeting when this was brought up.
I wouldn't argue the point to say, to add the word property, but
include
but total cost can be, well, the total cost of the house. You can misconstrue it, but ever since I guess I got appointed giving the little R licenses out when they first started, and that was part of my issuance of a license, was to say, to make sure you understand this includes the cost of the lot.
That was in the form that we gave.
It was.
Well, we can add it to this. We can add it to this rule if that's how you want to respond. We can amend it so to be added after 125,000. You want to say including land cost.
Yes.
Wait a minute. So if I this says remodel, repair, improvement of a single family dwelling, which I live in and already own the loan, and if I want to get someone with a limited residential license to come add a room onto it, they have to include the cost of my property?
But Bill, what
No,
was
it says also
happening
construction
was
as
people were
well.
using this
I think it would
license to
apply in
build new
construction.
construction.
Okay, I understand that. I totally understand that. If you're building a house to sell, but if we add including lot, then the circumstance I just outlined would be included. I'm not sure we should add the words including lot.
You got to have to include lot, because this worries me on this $125,000. It's worried me the whole time. I'm reviewing people don't even know what a footing is, and we're turning around and going to give them a $125,000 license. And
Originally designed for, just as Bill mentioned,
I-
remodels
right,
and add-ons. It was not designed for new construction.
right, but that's what's going on right here now.
It turned into that.
Right.
Then that's why we agreed on the form that we approved for them. It said total 70,000, including lot costs, just in case someone thought they could build a brand new home for that amount.
I would like to just say that this rule, this is the second time that it's been brought, and it got pulled after review by the Government Ops Committee for particular reasons, and I'd have to get the transcript, but I'm not sure, but the addition of this language may put us in the same spot. I don't know for sure, but based on my experience in front of the Government Ops Committee.
Members of that committee that questioned us, Reese was there too, and he can correct me if I'm wrong, did in fact see this as intended to let someone build small, like starter house, and totally build a house from the ground up. What we tried to do last time was say it was just remodel or add on.
Tried to remove
like
the
that.
word construction.
Yeah, we
just had
did.
to say remodel, repair, or improve a single family home.
And they wouldn't go for that.
No, they didn't.
So, but it seems to me that if I own a lot and ask, this will allow, if I own the lot and I contract with somebody, that they can come in and build a house up to $125,000 on it. And they wouldn't have to include the land because I already own the land.
That's correct.
So we have to be careful about where we add, including the lot, if we're going to do that. I just don't think it's necessary to do it, but because it's already been there.
Well, what I'm saying is the codes departments that I spoke to, the few that actually are utilizing this license are not being able to interpret it properly, and they feel some confusion, and they would like some clarification of what it does and does not include. May I suggest that we just say, in the case of new home construction, the lot cost is included? Cost. Yeah.
And if I own the lot and I've contracted with a builder to build it, that the way you just worded it wouldn't let him build a house for $125,000 because you have to include the lot cost of it.
Hey, unless provided by the owner.
Wouldn't include that lot.
Well, that's what I mean.
Unless provided by the owner.
$25,000 worth of improvements on that lot. Okay. I mean, bothers me. But,
yeah.
Yeah.
Okay, I just don't want us to do wording that does something we don't think it's going to do, is the only thing I'm saying.
I think the theory of the legislature was that whenever we passed this law originally,
Well, it's never been a law or rule, and that's why we're doing it today. Everything up until now has just been board policy. So I really wasn't prepared for the land argument. I mean, I don't necessarily think it's not doable, but I just have to remind everybody that this is why it's being done for a second time, is because the Government Ops Committee, like Bill said, did envision it to be for small new construction. So I need to know you guys' recommendation on the language.
Well, it seems to me if we're going to deal with the lot issue, it ought to be in the rule and not in this paragraph.
In a more general...
Under the new rules, which is below, instead of in this...
Okay.
See what I'm saying?
Okay, yes, I do. So are we ready to move on to the next rule? Okay. Rule 0680-01-.27, misconduct, is amended by deleting paragraph 3 and by substituting the following language so that as amended, the new paragraph shall read as follows. Pulling a building, electrical, plumbing, or light permit for a job in which an unlicensed contractor is the general contractor, or to consent or allow for a license number to be utilized by an unlicensed contractor in the furtherance of unlicensed contracting. I have a public comment that was emailed to Carolyn that I would just like to read into the record. Carolyn, I have a couple of questions regarding the upcoming hearing. In 62.6.111D, a contractor may bid on a contract requiring work in a classification or classifications other than the one in which the contractor is licensed, if and only if the contractor has a commercial building contractor's license. Or will the board be considering changing the description of a GC to a prime, subs to a remote? Does the architect get tagged if they allow an unlicensed person to bid work? What happens in our area is that a licensed GC will pull the permit, but an unlicensed person does the work. The state of Georgia has the law that if a GC pulls a permit for an unlicensed person to do the work, the person that pulls the permit has financial responsibility for the project. Also, as my own comment to the rule, I would like to add after the phrase unlicensed contractor.
Do you want to identify who wrote that?
I apologize. That's Roger Tudor of the AGC of East Tennessee. And I'll let you guys respond to that first.
I don't think we're going to be changing the description of a GC to prime and remotes. I think an architect may get tagged if they accept an unlicensed bidder.
Right? You're not supposed to.
Not?
No.
But wouldn't that be up to their licensing board? The only other comment that I had about the rule was I would like to add the language unlicensed contractor or improperly licensed contractor, because what I've seen also in the complaints is somebody with an inadequate monetary limitation or something using the license of another. So that's my own change that I would like to add.
I did receive one other phone call late yesterday from Bob Pitts from Associated Builders, and he would like to see the word acting remain in the paragraph.
Yeah, it should be marked out. I had taken it out, but
It's the next to last page of the rules.
so the rule would read, a job in which an unlicensed contractor is acting as the general contractor. And I had just marked those words out and just said the unlicensed contractor is the general contractor. I'm not sure his reasoning, but I don't think it's a problem. This is a rule we already had promulgate. It's already on the books, but I was amending it to just open up a little more leeway for my complaints. And I would just need a vote that you all would approve it with, well, we'll do that at the end if you approve any amendments. You can just let me know when you're ready to move to the next one.
I think the striked out version is in the iPad.
As amended with Bob Pitt's amendment and my amendment, it would read as follows. Pulling a building, electrical, plumbing, or light permit for a job in which an unlicensed contractor is acting as the general contractor, or to consent or allow for a license number to be utilized by an unlicensed contractor or improperly licensed contractor in the furtherance of unlicensed contracting. Okay, is everybody, any comments on that? Any public comments? Okay, those are the amended rules. The next is a new rule. It's Rule 0680-01-.29, Limited Residential License. Number 1, the limited residential license allows for the construction, remodel, repair, or improvement of single-family dwellings in which the total cost does not exceed $125,000. Number 2, the 10% tolerance for monetary limitations as stated in 0680-01-.13 is not applicable to the limited residential license. Number 3, the financial statements for limited residential license must reflect a positive net worth and positive working capital. Number 4, the limited residential license applicant shall provide proof of any relevant experience in order to qualify for licensure. Number 5, the applicant must participate in a restricted residential license 3-day course as approved by the board. The course may be taken at any location approved by the board. These courses are found on the board website. Are there any public comments on that rule? and I guess the board can take back up.
One more suggestion. What if we make it including the lot cost if owned by the contractor?
Why don't we say in the incidence of new construction? Not including the lot cost. Because I agree with Bill, we're getting into all kinds of confusing stuff if we start, because he's looking at the case of a remodel or repair or a home improvement that it says up here. And if we don't specify that it's for new construction, that the lot cost is not included, then we're gonna create mass confusion.
Let me say that we do have one rule in place now on monetary limitations that states, and I don't have it in front of me, but it states that the project value is quantified except for materials and labor provided by the owner. So, if that is how that...
Would you read your suggestion again?
Yes, sir. Total cost, including the lot cost, if lot is owned by the builder or contractor. And the reason for this, again, is the codes directors that have some folks utilizing this license are confused on whether to include the lot or not to include the lot. They read one thing, they hear one thing, and I'm just here in support of the codes directors being able to interpret this correctly. Of course, that's the people that actually have to be accountable to the state for how this license is utilized. And so I think it should be undeniably clear to them
Right here
how
in
they're
this
supposed
rule,
to issue the
They
permit.
shouldn't have to go to another part of the statute to find that.
Correct.
It's another part of the rule. I mean, it's just another rule
But
on
it
monetary
needs to be in
limitations.
this rule, therefore, that when they read it, they see it.
Well, I would suggest then that this rule reflect the other rule. I mean, if we're saying the same thing, which let me read to you exactly what the other rule says. The rule on monetary limitations states, subject to the 10% tolerance, no contractor shall engage or offer to engage in any project of which the cost, including all material and labor furnished by or through another source other than the owner, would exceed the monetary limitation placed on his license.
Apparently, what's there now is confusing for the codes directors.
But materials would not, you don't consider the land. Okay.
I don't think her suggestion was that bad. I thought...
I have not said it was bad.
Four or five more times before we get it. So.
No problem. Total cost to include cost of the lot if owned by the contractor.
You insert that in paragraph 1 of this rule.
Yes, sir.
At the end of the 125.
Either there or after total cost is where I was actually reading it into the rule, in which the total costing. Okay.
I'm okay with adding that to paragraph 1 at that point.
Is this where we need to make a motion then to...
Jenny, we're thinking we're okay with the language she just suggested.
Then,
and do we need to make a motion to add this to your text here?
yes, I think we need a motion to adopt the public, well, a motion to adopt your response to the public comment, and then I would like to read it as amended into the record.
Ed. Well, why don't you write it down for us real quick? And my understanding, Jenny, is that she wants to add this in paragraph 1 of this rule right after the words "the total cost," with the appropriate. I don't know the difference between lot and property, Counselor. Property may be
guess-
better because you could talk about a condominium, I guess, or something like that.
Yes, I would use property.
The other law calls
Won't
it
have to give them
property.
a license. This number 4 says
If the board's ready, I can read this part of the rule as amended. The limited residential license allows for the construction, remodel, repair, or improvement of single-family dwellings in which the total cost, including the cost of the property if owned by the contractor, does not exceed $125,000. And if you agree with that, I just need a vote that you agree with the amendment.
Motion that we accept the rule as amended.
Second.
All in favor, say aye.
Aye.
Any opposed? Okay.
If there's no other public comment, okay, then I would just ask the board for a roll call vote to approve all rules as proposed and amended before I read the next part.
And let me ask a question. This number 4 is the limited residential license applicant shall provide proof of any relevant experience in order to qualify for a license. Now, somebody's may get a lot of heat when we start turning people down. I'm just throwing that out because
I mean, these rules as drafted are based on past board approval.
what a foot needles at coming up trying to get a license. And give them a little R has been tough enough, but trying to raise that little R on up to from $70,000 to $125,000 is a big lick. Just throwing that out.
Make a motion, we accept the rules as read
And is amended.
and as amended.
We have a second.
And I need a roll call.
Roll call vote.
Aye.
Ellen, you gonna read the roll?
You call the roll.
That does not.
Ronnie Tickle. Ernest Owens. Bill Mason.
Aye.
Keith Whittington.
Aye.
Reese Smith.
Aye.
Cindy DeBusk. Marvin Sandrell. And Mark Rudd.
Aye.
Okay, now I need to read into the record the economic impact statement I've drafted up, the responses to the questions, and then the board can amend those if you feel like it's needed. The types, number one question is types of small businesses directly affected by these rule changes. The grounds for misconduct could potentially affect all small businesses that are licensed. The new rule regarding limited residential contractors will affect all licensees, including small business that are licensed as limited residential contractors. Number two, projected reporting, record keeping, and other administrative costs. There is no foreseeable alteration in small business reporting or record keeping that will result from the promulgation of these rules. Number three, probable effect on small businesses. There is no foreseeable substantial effect on small businesses by the imposition of the rules. Number four, less burdensome, intrusive, or costly alternative methods. the proposed changes to the existing rules are minimally burdensome, intrusive to small businesses. Number 5, comparison with federal and state counterparts. There are no federal counterparts to the issues addressed by these rules. Number 6, effect of possible exemption of small businesses. In order to ensure the health, safety, and welfare of the citizens of Tennessee, it is imperative that small businesses are held to the same standards as larger businesses regarding grounds for disciplinary action and license classifications. Many licensees are small businesses, and any exemption given to small businesses would undermine the rules of the board. And if there's any changes, and if not, would need a roll call vote on accepting the economic impact statement.
Ronnie Tickle.
Aye.
Ernest Owens. Bill Mason.
Aye.
Keith Whittington.
Aye.
Reese Smith. Cindy DeBusk.
Aye.
Marvin Sandrell. And Mark Brudd.
Aye.
Pursuant to TCA 45220 and 45228, any rule proposed to be promulgated shall state in a simple declarative sentence without additional comments on the merits of the policy of the rules or regulation, whether the rule or regulation may have a projected impact on local governments. The rules are not expected to have a financial impact on local governments. If there are any changes, please say so. If not, I need a roll call vote to accept that.
Aye.
Ernest Owens. Bill Mason.
Aye.
Keith Whittington.
Aye.
Reese Smith. Cindy DeBusk.
Aye.
Marvin Sandrell. And Mark Brudd.
Aye.
This concludes the rulemaking hearing unless the chairman has anything further.
Chairman has nothing further. We are adjourned.